Hello, good morning again, and welcome to our third lecture on the introduction to European law. Today, we are going to talk about the principles of EU law. We have dealt with the direct effects, indirect effects, and sources of EU law. Now, let's talk about the principles of EU law. There are four principles of EU law. We have the principle of supremacy, the principle of direct effect, which we just talked about, the principle of subsidiarity, and the principle of proportionality. These are the four principles of EU law. Now let's talk about supremacy or primacy of EU law. European constitutions are considered an international organization, or European community is an international or considered as an international organization. The relationship between international and domestic is governed by the idea of dualism. We talked about what dualism means when we talked about the introduction to law. So refer back to that lecture so that you will get to understand the difference between monism and dualism. So in European Union, the relationship between international and domestic law is governed by the idea of dualism. There are common goals of the European community. Treaties are created by legislative acts. How to define the position of the community law to the national legal system, etc. Now, what do you mean, or what do we mean when we say supremacy of EU law? Let us talk about it, the community perspective. The main issue in community perspective of supremacy of EU law are: 1. The character of EU law as the legal system. 2. The reasons for primacy and supremacy. 3. The relationship to consultations of member states. And 4. The relationship to incompatible national laws. Does it make sense what I'm talking about? Let me repeat it again. What are the major issues when it comes to the supremacy of EU law in the community perspective? 1. The first is that the character of EU law as the legal system. Secondly, the reasons for primacy and supremacy. Thirdly, relationship to constitutions of member states. And fourthly, relationship to incompatible national laws. Let us talk about the character of the EU law. In case Costa versus Enel, which we are going to talk as we progress in this course, in case number C6, 1964, between Costa versus Enel, by contrast with ordinary international treaty, the EEC treaty has created its own legal system, which, on the entry into force of the treaty, became an integral part of the legal system of the member states, and which their courts are bound to apply. This was the establishment of the ECJ, in this case, Costa versus Enel, in C6, 1964. You can find this case and read more about it as you venture into studying international law or European law or law in general. This case is a landmark case, and you will be hearing a lot about this case as you study international or European law. Secondly, it follows from all these observations that the law stemming from the treaty, an independent source of law, could not, because of its special and original nature, be overridden by domestic legal provisions, however framed, without being deprived of its character as community law and without the legal basis of community itself being called into question. This is as simple as that. What they are trying to tell us here is the supremacy of EU law over the laws of member states. We will get to understand this as we progress, but do listen to this once, twice, so that you get used to these cases that establishes the supremacy of the EC law over the national law. But the question is, why do Europeans want to impose this international organization as so supreme than their national law? Reason for the supremacy of EC law, as established by Costa versus Enel. Now, in this same case, the court establishes that the integration into the law of each member state of the provisions which derive from the community, and more generally the term and the spirit of the treaty, make it impossible for the states as a corollary to accord precedence to a unilateral and subsequent measures over a legal system accepted by them on the basis of reciprocity. Such a measure cannot therefore be inconsistent with the legal system. The executive force of community law cannot vary from one state to another in deference to subsequent domestic laws without jeopardizing the attainment of the objectives of the treaty set out in Article 5, Paragraph 2, and giving rise to the discrimination prohibited by Article 7. The court went further to say that the transfer by the states from their domestic legal system to the community legal system of the rights and obligations arising under the treaty carries with it a permanent limitation of their sovereign rights, against which a subsequent unilateral act incompatible with the concept of the community cannot prevail. Do you understand what they are saying here? They are trying to justify why European law acquires the supremacy rights over the national courts or national law. So they thought this well, and that is why European Union is it's a supranational country now, and worthy to be emulated by other parts of the world, because the way the system is structured, it is very unique. And think about it. An independent nation like Netherlands will submit all their power, hand over their power to an organization and say, Lord, take me, do what pleases you. Who does that? But that was what the Europeans did, because they need a better Europe, they need a functioning Europe, they need a peaceful Europe, and they need a global power Europe. And in order to do that, they had to sacrifice their sovereignty and hand it over to an organization and say, Lord, do whatever you want with me. We are yet to see how it goes. But this is what was established here in the case Costa versus Enel. In summary, in this case, Costa versus Enel, the following were established. Community laws must be given primacy by a national court over an incompatible national law. Secondly, spirits and aims of the treaty shows that it is impossible for the member states to accord primacy to domestic law. Thirdly, since the aim is integration and cooperation amongst Europeans, it is not possible to achieve this aim if one member state can refuse to give effect to community law. It's as simple as that. The language in Article 288, formerly Article 189, would be meaningless if states could challenge the supremacy of community law by passing subsequent and inconsistent legislation. The ECJ used a teleological rather than a textual approach in interpreting the treaties. It underlined the aims and spirit of the treaty. I also say kudos to the ECJ, because without the ECJ, what we have today as European Union wouldn't have been possible. ECJ fought so hard to establish a very solid, unbreakable system. So I give my kudos to the ECJ. Now let's talk about the relationship between national constitutions. Now, this relationship was established in a case in Germany, International Handelschaft, in case C11, 1970 or so. In fact, respect for fundamental rights forms an integral part of the general principle of law. That is true. This general principle was protected by the Court of Justice. The protection of such rights, whereas inspired by the constitutional tradition common to the member states, must be ensured within the framework of the structure and objectives of the community. It must therefore be ascertained in the light of the doubts expressed by the Verwaltungsgericht in Germany, whether the system of deposits has infringed rights of a fundamental nature, respect for which must be ensured in the community legal system. Recourse to legal rules or concept of national law in order to judge the validity of measures adopted by the institution of the community would have an adverse effect on the uniformity and the efficacy of community law. The validity of such measure can only be judged in the light of community law. In fact, the law stemming from the treaty cannot be overridden by rules of national law, however framed, without being deprived of its character as community law. Therefore, the validity of a community measure or its effect within a member state cannot be affected by allegation that it runs counter to either fundamental rights as formulated by the Constitution of that state or the principle of a national constitutional structure. What are they trying to do here? In Germany, they had an issue where the German court was trying to prove that the German constitution should not be handed over to European judge like that. That the German constitution has to be seen as more superior than the European Community Act, but that argument didn't work. So in this international Handelschaft case, it was established that no matter what, the national constitution must bow to European constitution. That was the beginning when Germany tried to fight to protect their constitution over the European constitution, but it eventually failed. So you try and find this case, International Handelschaft, and you will see how in Germany it was established that German constitution can never be supreme over the European constitution. We will deal more about these kind of cases, especially German constitution and French constitution tried so hard to fight against the supremacy given to European law, but they eventually failed. So, but we deal with these kind of cases later as we progress in the introduction to European law. Now, let us give a summary of European law perspective. The summary of European law perspective could be addressed into the following. The European law is based on the constitutional tradition of member states. That is for sure. The ECJ accepts protection of fundamental rights as part of the general principle of law. That is the second perspective. The third perspective was that the constitutionality of EU law cannot be challenged by any national constitutional court. Who dare you to challenge the European Constitution over any national constitution of the member states? It is not possible. Some countries like French and German tried it, but it didn't work. Therefore, EU law should prevail over constitutional norms as well. How are we going so far? European law is fun, yeah? Okay. Let us talk about the relationship to compatible or incompatible national laws. Relation to incompatible national laws in the EU. It says that if national law is incompatible with EU law and EU law has supremacy, what shall be applied? Shall the national law in conflict be abolished or cancelled? Shall there be an automatic application of prevailing EU laws? These were the questions that arose during the initial stages of the formation of the European Union. Arguments of the states based on the Constitution. Some states argue that if there is an incompatibility between rules of law and one has supremacy, the inferior rule shall be reviewed by the Constitutional Court and cancelled or abolished. Another argument states that on the basis of Constitution, it is not in the jurisdiction of national courts to review the legality of national rules. Now, in order to answer all these questions, we will go to other cases. This is a Simmental case, also in Germany. Simmental case 106. Or I think it was not Germany, it was, I think, Italy. The Italian authority argued that national courts could not simply refuse to apply a national law which conflicts with community law, but must first bring the matter before Italian constitutional court to have that law declared unconstitutional. The ECJ said bullshit. The ECJ said bullshit. This is not in the spirit of why we became a community. They automatically rejected this argument by the Italian courts. Their approach was that the ECJ rejected this approach in Simmental case and stated that national judges should automatically refuse to apply any national law which is contrary to EU law. This is how law works. Not all these things are made in Africa, especially my mother country, Nigeria, messed up all the system. See how the ECJ shut up the Italian court. He told them that the national judge should automatically refuse to apply any national law which is contrary to EU law, establishing the supremacy of the EU law here. Relations to incompatible national law in the second Simmental case. Furthermore, the court stated that in accordance with the principle of precedence of community law, the relationship between provisions of treaty and directly applicable measures of the Constitution on the one hand and the national law of the member states on the other is such that those provisions and measures, not only by their entry into force, renders automatically inapplicable any conflicting provisions of current national law, but insofar as they are an integral part of and take precedence in the legal order applicable in the territory of each of the member states, also precludes the valid adoption of national legislative measure to the extent to which they would be incompatible with the community procedure, lex posterior. So, here, the EU law is establishing its dominance over national constitution and over national laws. It is claiming its supremacy. Now, having established this, now it is now clear to us how supremacy of EC law was properly established. It follows from the foregoing that every national court must, in a case within its jurisdiction, apply community law in its entirety and protect rights which the letter confers on individual, and must accordingly set aside any provisions of national law which may conflict with it, whether prior or subsequent to the community rule. This is done and dusted. Now, supremacy of EU law continues also in the same case, Simmental, to the effect that a national court which is called upon within the limits of its jurisdiction to apply provisions of community law is under a duty to give full effect to those provisions, if necessary, refusing of its own motion to apply any conflicting provisions of national legislation, even if adopted subsequently, and it is not necessary for the court to request or wait for the prior settling aside of such provision by legislative or other constitutional means. No need to wait the parliament or constitutional court. Did you hear this? No politics. The ECJ says you cannot refer any conflicts back to the parliament or back to your Supreme Court. You have to interpret it to suit the community law. Simple. No diplomacy, no politics, no bullshitting. Did you see how the supremacy of EC law is continuously being established? Now, it continues in the same case. What if national courts have no domestic jurisdiction to question or to set aside national legislative acts, like in the UK? Messages of the ECJ to all EEC members. Even if the Constitutional Court is the only national court empowered to pronounce on the constitutionality of a national law, where a conflict between national court and community law arises before another national court, that court must give immediate effect to the community law without waiting the prior ruling of the Constitutional Court. You see how Constitutional Court was reduced to nothing. So, the understanding of the ECJ is simple. Supremacy of EU law is a kind of automatic precedence of directly effective community law over national law. Simple. Now, supremacy of law, of EU law, continues here. What about the fate of inconsistent national law? The requirement to set aside the conflicting national law does not entail an obligation to nullify national law. Do you understand what he says? You don't even if your national law is clearly in conflict with the community law or the European law, and you are a nationalist, and you don't want to insult your constitution or your law, the ECJ is telling you, if that is the situation, which may continue to apply in any situation which is not covered by a conflicting provision of community law, the principle is confirmed in the case of Fatome. So the ECJ is telling you, when it is very clear that your national law is so conflicting with the community or European law, just don't say that it is conflicting. Just put it aside and move on. Continue with your interpretation that is going to suit the European community kind of interpretation. So in order to establish this, there was this second case, the Fatome case, either to disapply the national law or to nullify the national law. And some judges or some courts of national law are so nationalistic that they respect their constitution, and they find it so difficult to say that their constitution, So the ECJ told them, no worry. Don't nullify, don't say that your law is bullshit. Just disapply, forget whatever your constitution says and apply what is the status quo. Status quo now is the supremacy of EU law. What did EU law want? What did the EU law say? Just move on. Don't bother to nullify the conflicting act. Just jump over it and do what is needful. Now, in summary, supremacy or primacy of EU law, that is principle of precedence of community law, is not stated in the founding treaty, but established by the ECJ through its case laws. You see what I said, why I gave kudos to ECJ? Because initially, when they drafted the ECC or European Union Constitution, they did not actually give the Constitution primacy. But when problems started happening everywhere, states violating the community directives, so the court had to jump in to save the situation. So, it is not stated in the founding treaties, but it was established by the ECJ through its case laws. It means, 1, validity of EU law cannot be assessed by reference to national law. No. National court must give immediate effect to directly effective EU law of whatever rank in cases before them. National court should ignore or set aside any national law of whatever rank which could prevent the application of EU law. Are we making sense? Perspective of member states of EU. 1. Most of the EU courts or most of the national courts do not accept unconditionality monist approach of the ECJ regarding supremacy. In practice, they accept supremacy, but most of them sees this as deriving from their national constitution, not from the authority of EU treaty or ECJ. These courts keep a power of ultimate final constitutional review over measures of EU law. But this is just to be diplomatic. They have accepted, they don't have any choice. So whatever is their opinion about their national constitution or whatever, the fact has been established. EU constitution has primacy, has supremacy over anything national. Now, like I told you before, Germany and French constitution tried so hard to fight in favor of their constitution. Let's see some of the example how French and Germany fought to no avail to give their constitution supremacy or whatever. Now, French Council d'État recognized the supremacy of regulation and directives over French statutes, but it has not recognized the primacy of EU law over the French Constitution itself. This is why, in case an inconsistency is identified, the French Constitution is amended. Constitution was amended many times in France in order to bow down for the EU law. In 1992, for example, amendment to give effect changes by Maastricht Treaty, right to vote and stand in municipal election. In 1999, amendment to facilitate ratification of the Amsterdam Treaty. Also, like I said, Germany tried also to diplomatically accept this, pride now. So, Article 24, paragraph 1 of the German Constitution says that the Federation may, by a law, transfer sovereign power to international organization. But does this article permit the transfer of power to contravene certain basic principles under the German Constitution? German Constitutional Court answered this question in two famous cases, in Solange 1 and in Solange 2. Let's talk about the Solange 1 case. The part of the Constitution dealing with fundamental rights is an inalienable essential features of the valid Constitution of Germany. Cannot be taken away from you, okay? The community still lacks a democratically legitimate parliament directly elected. It still lacks, in particular, a codified catalogue of fundamental rights. Provisionally, therefore, in case of a conflict between community law and the guarantees of fundamental rights in the Constitution, the guarantees in the Constitution prevails as long as the community keeps this structure in force. Therefore, the Constitution or Constitutional Court of Germany refuses to recognize unconditional supremacy of community law. This was because of the concern of the Constitutional Court over the possible impact of EC law on basic rights enshrined in the German Constitution. Therefore, such fundamental rights shall prevail in case of conflict with the community law, as long as the community continues to have such a structure. This was the stand of Germany then in Solange 1. However, in Solange 2, having considered various changes in community law since 1974, like ECJ doctrine of protection for fundamental rights, all member states had, including Germany, acceded to the European Court for Human Rights, the German Constitutional Court stated in Solange 2. In view of these developments, so long as the EC and the case laws of European courts generally ensure an effective protection of fundamental rights as against the sovereign power of the community, which is to be regarded as substantial, similar to the protection of the fundamental rights required unconstitutionally by German Constitution, and is in so far as they generally safeguard the essential content of fundamental rights, the Federal Constitutional Court will no longer exercise its jurisdiction and will no longer review such legislation by the standard. You see, of fundamental rights contained in the Constitution. So eventually, after doing gra, German Constitution eventually decided to bow down for the European law to be supreme over the German Constitution. Therefore, in principle, the court may not review, but this is because of its own decision and discretion, not because of ECU. Okay, whatever, but at least you're coming around. The Constitutional Court did not give up its jurisdiction. Okay, pride. Or come to the conclusion that no such jurisdiction exists. The court wanted to preserve its final authority to intervene where problems concerning to the protection of human rights in community law could arise. We know. Also in Germany, in another case, the German Constitutional Court has stated in Solent human rights protection within the EC legal order was generally comparable to the level of human rights protection under the German Basic Law. Therefore, application to constitutional courts attacking secondary community law on the basis of German fundamental rights would be inadmissible if they did not argue that the general level of human rights protection fell below the necessary level on the basis of comparison with the German level of protection. Also, in 1994, the constitutionality of the state's ratification of Maastricht Treaty was challenged before another German constitutional court. The court affirmed then the supremacy of the German state or the sovereignty of the German state. The court warned the community institution and the ECJ that Germany's acceptance of the supremacy of community law is conditional. The German Constitutional Court stated the scope of its jurisdiction to review. 1. Whether EU institutions have remained within the limits of their powers or travails control. Or 2. Whether EU institutions violate the basic constitutional rights of German inhabitants. You see how Germany and France fought to protect, to give respect to their constitution, but eventually they gave up. This is where we end today's lecture on the supremacy of the EU law. And I urge you to take your time, listen to the lecture 1, 2, twice. Our goal here is to make sure you get your A's or your B in your introduction to European law or introduction to law or introduction to international law. I wish you good luck and see you again in our 4th lecture on this course, the Introduction to European Law. I hope you enjoyed the course and I see you next week. Have a nice weekend. Bye.